and welcome to the September 19th Legislative Commission on Data Practices. The first order of business would be approval of minutes from August 8th. Representative Lesh, if you have the opportunity to look at those minutes.
No, but I'll move them anyway.
All right. Any discussion on the minutes? Seeing none, all those in favor, please signify by saying aye. Aye. Opposed, same sign. The minutes are adopted. Today we're going to be talking about educational data, and more specifically what the rights of students and parents are when it comes to educational data. And of course, with the advancements in technology, we also are going to be hearing about Representative Lucero's bill on student data privacy. Many of you know that many times schools issue computers, laptops, tablets, what have you, and we are interested in what rights a child has within that when those devices are issued. And so we'll be hearing about that today. So what we're going to do first, and by the way, if you're in the audience and not aware, Representative Lucero's bill is House File 1507. So if you don't have a copy of that, you might want to grab one or look it up on your phone or your mobile device. First of all, we're going to have an overview of the federal and state laws governing access to student records. And first on the docket is Cristina Parra Herrera. She's the legislative analysis and House research on this topic. And then we'll hear from Ms. Mullen, Mary Mullen, legislative analyst and House research. I guess they're coming to the table together, which is awesome. Welcome to the committee. Please state your name for the record and proceed with your testimony.
Cristina Parra of House Research.
Chair and members, Mary Mullen, House Research. Cristina is going to start us off kind of with the overview of federal student data privacy laws, and then I'm going to jump in here and we'll kind of go back and forth.
Perfect.
So we'll start with the FERPA, which is the main federal statute governing data privacy. FERPA is the Family Educational Rights and Privacy Act. Protects the privacy of students and parents, and it's three key aspects of that we'll be focusing on. The right to inspect and review education records, the right to request amendment of education records, and restrictions on disclosure of information. FERPA applies to education agencies and institutions, institutions that receive federal education funds and that provide educational services or instruction or direct or control an education institution. So we're talking about things like public and private schools, school districts, and state education agencies, the Department of Education. Education records are defined under FERPA as information that is recorded in any way that contains information directly related to the student and is maintained by an education agency or institution or a person acting on the institution's behalf. That definition is technology neutral, so it's information recorded paper, digitally, in any way. There's not a lot of case law on these definitions or in FERPA generally, and I'll get into that a little bit. But there are questions about what it means for a record to be maintained by an education agency. Parents and eligible students have rights under FERPA, and generally the right belongs to the parent, but it transfers to the student when the student turns 18 or goes on to a post-secondary institution, and that's what we mean when we refer to an eligible student. And it's the right to, as I said, to inspect and review the education records, to request that those records be amended, to consent to disclosures of the records with some exceptions, and to file a complaint with the Department of Education, with the federal department. There is no private cause of action, meaning an individual can't sue for a violation of FERPA, the enforcement is done through the Secretary of Education. And the Secretary of Education can withhold federal funding because if there's a violation of FERPA. Parents can request amendments of the education records. If a school won't amend those records, there's a formal hearing process. And then if that doesn't lead to a resolution, a parent can submit written comments to be included in those records about the contested information. Parents must consent to disclosing a student's personally identifiable information before that information is disclosed, unless an exception applies. There's no definition of PII, but the regulations say what PII includes. So that's things like names, address, social security number. It also includes other information that, whether alone or in combination, would allow a reasonable person in the school community to identify the student with a reasonable certainty.
Ms. Herrera, I have a question back on the enforcement. And so if there's a hearing where a parent has made a request for some data and they feel like they haven't gotten the data, is that done at the local level then, the hearing?
Yes, the hearing, I'll have to get back to you on that and more of the procedures for the formal hearing. But yes, there is a formal hearing process, and then there's also a separate complaint process for somebody to file the complaint with the federal agency.
Okay, thank you. Go ahead.
Schools, and when I say schools, I'm generally talking about the agencies that have responsibility under FERPA. I'm just using schools as a shorthand. But schools must tell parents about their right to inspect and review records. Parents must be informed about their right to inspect, review, amend the records, to consent to disclosing PII, and to file a noncompliance complaint. Schools also have to record requests for PII. The regulations have some more specific requirements for what information the school has to record. For example, the reason that this party is making the request. And there are some exceptions to when the school has to record the request. If it's, for example, to a school official or somebody seeking directory information. We'll talk a little bit more about directory information, or if the information is obtained through a subpoena or other court order. Schools may disclose some information without consent. They may disclose student directory information, de-identified information, and some PII. Directory information is, the schools designate what they believe directory information is, but they have to notify parents what that information is, and parents must have an opportunity to refuse to disclose that information. And then once that information is defined, the parent hasn't objected, the schools can disclose that information to anyone without consent. And there's a list of the types of information that can be designated directory information, things like name, address, email address, et cetera.
And parents can opt out of that if they want to, right?
Yes, Madam Chair, parents can opt out of that. Schools may disclose de-identified information without consent. They have to make sure that they've removed all the PII and determined that the student is not identifiable, and that's something they may do, for example, for research purposes. Schools may also disclose PII without consent in some cases. For example, school officials with legitimate educational interests, contractors, consultants, if they're performing some institutional functions. So one thing to consider is, for example, cloud computing service providers that are performing some of these functions. They would be subject to FERPA as well as some other laws. Schools, other exceptions include if a student wants to transfer to a different school, officials of those at that other school, they would be able to obtain the information without consent. Certain other governmental entities, testing, if there's a financial aid application, crediting organizations, subpoena, health or safety emergencies, and the juvenile justice system. Additionally, for students with disabilities, the Individuals with Disabilities Education Act has some provisions that govern access to education records. IDEA governs access to records relating to the student's disability and education services that are provided under an individual education plan. And there are also some reporting provisions, crime reporting provisions that work with FERPA. The PPRA is the Protection of Pupil Rights Amendment. It applies to K through 12, so not post-secondary schools. It generally relates to surveys, both marketing surveys and certain other surveys. So, for example, it requires 3 types of notification: a general notification to parents of their rights under PPRA, notification of specific events. So if there's a survey that is a marketing survey or one of the other surveys covered under PPRA, and also notification of the policies that local education agencies must adopt. That allows parents to inspect the survey's materials and requires parent consent if the surveys reveal certain information. There's 8 kind of protected areas that covers things like political affiliation or psychological problems. If it covers one of those areas, then the parents have to consent.
Chair and members, the next few slides talk about other tools that are available to protect students' privacy. These relate a little bit more broadly to their use of the internet. The first one I'm going to talk about is COPA, the Children's Online Privacy Protection Act. This is a federal law that was passed almost 20 years ago. And there were new rules that were put out by the Federal Trade Commission in 2013. The rules sort of highlight how COPA works. The websites have to post clear and comprehensive online privacy policies about personal information that's collected from children. They have to provide notices to parents and obtain parental consent. Choices about how the children's information is used and disclosed to third parties. And one of the things to keep in mind about COPA is that it applies to children who are 13 and under. It does not apply to older teenagers. Some of the other laws that apply that are related to student conduct include the Children's Internet Protection Act. This is the law that's in public schools and libraries when they or any school that receives federal funding about filtering internet content when the computers are accessed by children. There's also Minnesota state law related to crimes for soliciting sexual content from minors or sending sexual content to minors. And then there's also the cyberbullying law, which is also in Minnesota statute about bullying, which of course extends to any conduct on the internet or through social media. So those are a few other laws to be aware of when you're thinking about students' privacy. Now I'm going to talk a little bit about the Minnesota Data Practices Act and how it sort of supplements FERPA. FERPA sets the minimum data practices standards that states can have, but then they can also supplement them and pass stronger protections for students. The Minnesota Data Practices Act in Chapter 13 regulates data practices, and the Minnesota law basically adopts FERPA and adds other restrictions and requirements. Some of those additional requirements are that Minnesota law requires a Tennyson warning. Thank you. To let students know the purpose and the intended use of data when it's going to be shared. It also allows minor students to give informed consent to disclose educational data, and it allows minor students to request a school deny the student's parent access to data about the student in certain circumstances. So those are all a little bit different than the way FERPA operates. The student does have a little bit more control over the data.
Ms. Mullen? It says here allowing a minor student to give informed consent. Can they give that informed consent without their parents' approval?
It sort of depends on the age of the student. That is kind of one of the areas that's a little bit grayer in that law. But it does depend on the student and kind of their age and maturity. And it's, if you want more information about that, I think that the Minnesota Data Practices Office would be a good one to ask, because that is sort of, it's not in conflict with FERPA, but it definitely is very different than the way FERPA operates.
Because I'm just thinking of a scenario where a child may not have the level of expertise to make that decision, and they may make the decision, and their parents have no knowledge of their child making a decision to, say, have their data shared with something or with some other entity. That just seems like, that just seems backwards to me, but, yeah, go ahead.
Thank you. Couple other ways that it differs from FERPA is that it can release the education records subject to a court order, but not a subpoena. FERPA does allow information to be released by subpoena. It prohibits parents from inspecting teachers' desk notes, but does allow parents to inspect desk notes of other school personnel. Again, that is different from FERPA. And it allows parents to designate an additional person to participate in school conferences. So you've heard a little bit about federal law and the Minnesota law. I'm going to talk now about some trends that other states have. Some of the newer state laws related to student data privacy are kind of fall into three different areas. One of them is prohibiting entities from collecting certain types of data, so making more restrictions on the type of data that's collected. Some of the laws are improving state and local government policies and practices related to the data and how it's collected. And another category is establishing guidelines for how third parties handle student data. So what happens when the data leaves the government's hands, or these would be the school's hands. And those are kind of three categories where some state legislatures have been working.
Madam Chair, members, and just to give you an idea of the types of data that, that the state is collecting, the Department of Education, they collect data under both federal and state law. Under federal law, that would include the IDEA. I understand they must send a number of reports each year to the federal government with some of the data they collect. Also under various state laws, the Department of Education has to collect data on discipline, annual school performance reports, SLEDs, which I'll talk about more in a minute. So that type of data includes things like testing, MCA scores, enrollment, demographics, attendance, college readiness. So beyond the MCAs, it's things like advanced placement and international baccalaureate programs, as well as early learning programs. SLEDS is the State Longitudinal Educational Data System, which matches student data from pre-K through completion of post-secondary education into the workforce. Under Section 127A20, the Minnesota P20 partnership governs SLEDS, and the idea is to expand reporting to evaluate what programs are effective, what educational and workforce programs are effective, and to evaluate the relationship between education and workforce outcomes. On this, the SLED system is on the MDE website, so you can go on and take a look at the kinds of data that they have there. There's also now the Early Childhood Longitudinal Data System. That's something MDE is still developing. But the idea is to look at growth and achievement in relation to participation in various state programs. So for example, you could go on there and look at how many kindergartners are receiving economic and food assistance. And that's also on the MDE website. The Minnesota Student Survey, MDE also maintains that, but it's really a partnership between MDE and other state agencies. And it asks young people about their activities, opinions, behaviors, and experiences to provide data for program planning and evaluation. As I talked before about that PPRA, the statute on surveys, which requires parental notification and allows parents to review the survey. So the student survey is subject to that, and parents can opt students out of it. Students can also stop taking the survey even once they've started. And the surveys are anonymous.
Chair and members, the next section we're going to talk about is issues related to student data use, privacy, and security. This first slide is about privacy protections for longitudinal databases, which was what Cristina was just talking about. And kind of the thing I would highlight is that aggregate data currently is not covered by these privacy statutes. So some of the policy considerations are what is currently collected by, what's required to be collected by state and federal law, and then what other data is collected. Is all the data aggregate data that is anonymous for any individual student? Do third parties agree to and follow privacy requirements? Should there be a limit on what data is collected? What are the retention policies? What are the access, what can be accessed, and should audit logs be used in those circumstances? And is the information on longitudinal studies available to the public? These are just a few things to think about when you're thinking about aggregate data and how it's used. The next slide is about school data storage and retention policies. So this is, what schools have and how long they keep it. What are those concerns about that data? Well, one of them is that schools are using computers and tablets. Those are issued to students. This allows for more data to be captured and more information that may or may not be related to educational purposes, things like GPS information about their location, internet use, personal notes, emails. School districts are using online service providers for scheduling, data processing, managing all different kinds of things, anything from their finances to the student records themselves. And then the internet and software allows students to be tracked, recorded, and saved depending on what the activity is. FERPA allows students to share directory information with third parties, and few parents tend to opt out. District agreements may or may not restrict vendors' use of student information. So these are the third-party contracts with vendors, and some people have raised concerns over this vendor sharing information. So these, again, are just policy considerations when you're thinking about working with third parties. The third-party vendors may collect and combine student data with other personal data and non-school sources sufficient to develop student profiles and targeted advertising to students. Again, that's been another concern that people have had, is really that targeted advertising and how they develop those profiles.
Ms. Mullen, I just wanted to point out on the, where FERPA allows the schools to share directory information with third parties and few parents opt out. That could be something, as you mentioned before, that the state's law could be more restrictive than the federal law, and we could say, yeah, you can't do that. Am I right?
So I think probably what a state law could do is it could create more informed consent related to that directory information sharing. So if the state, that would be one area for sort of a policy consideration, would be why are few parents opting out if you think maybe parents would want to opt out of that? And looking at ways that you could get parents more information about what type of data that directory information is and how it's shared. So perhaps more disclosure or better information to the parents who are making those decisions.
Yeah, because my point is if we try to do something here on the state level, but the federal level says, no, you can share this information, then where does that leave us? So, all right, thank you.
So the district agreements may or may not restrict vendors' use of student information or the sale or marketing of the information, and vendors may sell or exchange student profiles related to the directory information under FERPA. Third-party vendors can collect and combine student data, as I was talking about, just to target advertising. So this next, we can say it, sorry. So this is this kind of California law that was passed on student data privacy tries to get at some of those issues I was just talking about, the kind of broader internet use, but also the targeted advertising. So the law prohibits K-12 websites, online services, and apps from using, selling, or disclosing students' online searches, text messages, photos, voice recordings, biometric data, food purchases, political or religious information, student IDs. The law is trying to get at some of the more sensitive information that may or may not be directly related to education, kind of things that are outside of the student record itself, that are collected inadvertently through the use of various different forms of technology. House File 1507 appears to be aimed at remedying some of the issues around these third-party contracts and technology similar to the California law related to student record keeping. And I'm going to actually come back to that in just a minute and kind of expand on it. But first I'm going to get to another issue that's also related to this additional information that's collected, via using the internet, software, and using these devices, is students' ability to delete their digital footprint. Outside of school, what are the students' privacy rights online? That's a big question mark right now. Family, friends, and college admission officials, potential employers can see students' digital footprint, and those things could potentially follow a student for a long time. California enacted privacy rights for California minors in the digital world. This is sort of, they call it an eraser button law that became effective in 2015. And that law is aimed at getting at some of those, some of the internet-related activities that students are engaging in that could follow them, and ways to delete that information that don't exist right now under current law. So back to House File 1507, what this bill specifically does, as it's written right now, it regulates the use, access, and distribution of data on electronic devices that are provided by the school and on the software used by students for schoolwork, and that maintains the students' records. The bill covers anything considered to be student data by the Minnesota Data Practices Act and also by FERPA. It has a very broad definition of educational data. And the bill provides for disclosures for parents and students about the data that's collected so that they know what data is collected and how it can be shared. It requires certain contract provisions to bind the school and the hardware and software providers. So then the contracts themselves, along with the new statutory provisions in the bill, FERPA, and the Minnesota Data Practices Act, control what can be done with that data. The bill also creates additional rights and remedies for students and parents, emergency provisions for accessing data in an emergency, and training requirements for schools related to data privacy. That completes our presentation.
Thank you very much. Are there member questions regarding any of this presentation? Senator Limmer.
Thank you, Madam Chair. I wanted to ask a question that the chair asked before, and is it correct to say that Minnesota cannot write privacy law for students that are stronger than the federal FERPA provisions?
Ms. Mullen?
Chair and members, yeah, I would clarify that. Minnesota can write stronger provisions. The Minnesota Data Practices Act supplements FERPA and goes further than FERPA does. But it couldn't write anything that's in conflict with what is currently in the federal law.
But wouldn't an excessive protection written by the state be in conflict with the federal?
It would, Chair and members, it would depend a little bit on what that is. If there's something in FERPA that says that something must be public, then no, the state would not be able to pass a law that says that it is private. But in places where there is no protection and there's no federal law on that particular issue, then the state could pass something that helps to protect student privacy.
Madam Chair,
Senator Limmer.
there's a lot of issues in here that I was picking out of the handout. If I could turn you to slide 10. This week, slide 10, page 5 of the handout. It says schools may disclose directory information without consent. what would directory information be? Is that similar to a telephone book information, or is it something a little more detailed?
Ms. Herrera?
Madam Chair and members, the school designates what is directory information. It is things like names, address, telephone, email. There's a list of things that it can include. So the school designates what the directory information will be and must provide notice to parents. This is the information that will be disclosed, and then parents can refuse consent for that.
Then who would be the author of the list that they could choose from? Is that the
Herrera.
federal government?
Madam Chair and members, the school district, in this instance, it would be the school district that would send the notice to parents.
Well, Madam
Senator
Chair, the way I understand this is then, if that's true, couldn't that result in a patchwork of different pieces of information from district to district that could be accumulated and kept on a student without their consent, different from another school district? And with that type of patchwork application, is that a direction that the state would want to continue to adopt? What's the benefit of having that type of policy?
Ms. Herrera?
Madam Chair and members, FERPA imposes the responsibility on certain agencies, and so it includes schools and school districts. The way that we do it in Minnesota is each school district has a lot of autonomy over any number of things, and this would be one of those things. So each school district may be making different decisions about what the directory information for its students would be that might differ from Minneapolis to Rochester to, all around the state.
Madam
Senator
Chair,
Limmer.
just as I'm thinking about this, I know we try to strive to have an equal education for each student in the state of Minnesota, but by having this patchwork of separate standards, are we violating that equal application under the law?
Ms. Herrera? Or Ms. Mullen?
Yeah, Chair and members, I think that those are really good questions to ask, but I think that maybe the Minnesota Department of Education would probably be able to provide better rationale for how those individual districts make those decisions. I thought that would be maybe a good question for them.
Other member questions? I know there is a section in Chapter 13. If you're interested, folks, 13, 31, and 32, right, are all about, and maybe more than that, nope, are all about student data, educational data. So it's 13, starting with 3.319. And then there is a section, a subdivision on directory information. So if you're interested in that, take a look. I'm tempted because I see my own school superintendent sitting in the audience, and I'm really tempted to phone him up and see how Anoka Hennepin handles this directory information. Would he be willing to take the stand?
Well, that's not why I came, but
If you know the answers to the questions, and that's not something that maybe you delegate to someone else, that'd be great. Superintendent Law, that's what you get for sitting in the chair in the room. If you would introduce yourself for the tape, that'd be terrific. Thank you for coming forward.
absolutely. Committee members, representatives, senators, my name is David Law, Superintendent for the Anoka Hennepin School District, and Senator Limmer, yes, directory information is a local control decision. The types of information that are considered directory information are students' first and last name, school of attendance. Typically, the kinds of things that we make directory information allow us to print a yearbook or a sports program. So because we're making those publications available to the community, surprisingly, many districts have a student's height and weight as required by a basketball program or a football program. We try to keep that as a district to a minimum, But we know that there are publications we create for the community, like a yearbook, that would require us to put a person's first and last name, the grade they attend, clubs and organizations that they participate in, so that we can print a yearbook and students can see that information that's available to the public. Beyond that, districts could choose a variety of other things based on something unique in the community. I can't come up with a good example right now. I've worked in 3 school districts. What I've just shared are the most common things, but every district has a model policy on what is considered directory information for parents to see. And we are typically very reluctant to share any student data outside our system. Even when we get requests for organizations who are doing research, we make sure that nothing in the data that we would share as an aggregate would be individually student identifiable. It might say a whole grade's MCA proficiency, like the Minnesota Department of Education might publish for accountability purposes, but not individual student or school level information, if that helps.
I'm sure.
Senator Lemon.
I'm sure. Superintendent, so am I to conclude that directory information does not include identifiable information on a student?
A student's name and grade are identifiable information, absolutely.
But there's no home address?
No,
Phone number, any like
the
that?
districts that I've worked in have not included home address and most often not parent information. So there are, I'll give an example, like a PTA or PTO might ask all the parents to submit their name for a directory at a school because that isn't directory information available at the district level. But that is a local control decision.
Other questions? Thank you for being the expert witness today.
Thank you, Representative Scott.
Other member questions on this information? With that, we do have some people that have signed up to testify. And so I have 4 people on the list. We will start in the order that they're listed here. Stephen Knutson, Minnesota School Board Association. And on deck would be Ben Feist with the ACLU. And then Linda Bell and Kirsten Schultz. Did you have some shoulder surgery?
I had an unfortunate incident walking our 1-year-old, 25-pound Corgi puppy. And he loves to run through sprinklers, and I ended up with a torn rotator cuff. So I had surgery 3 weeks ago.
Oh, I'm sorry to hear that.
So I may be a little bit more labored in my comments since I had trouble flipping pages with one hand and looking at things.
No worries. If you could introduce yourself for the tape and go ahead with your testimony, that would be terrific.
Yes, my name is Stephen Knutson. I'm with the law firm of Knutson, Flynn, and Deans in Mendota Heights, and we represent a number of school districts throughout the state of Minnesota and are also general counsel for the Minnesota School Boards Association. Now, I will tell you right now that I wasn't exactly aware of what the comments were going to be at this particular proceeding, so I'm kind of going to be shooting from the hip. But what I want to do first is I want to clarify a few things as far as the presentation thus far. And okay. I just want to, first of all, tell you what, from a general practitioner's standpoint, as far as FERPA is concerned and some of the arguments that we face when we go into litigation, I will tell you that there are a number of decisions that question whether FERPA actually prohibits the release of private educational data. Some of the cases, which I would advise you are probably incorrect. They say it really doesn't prohibit the disclosure. It just says you can lose funding if you disclose the data. I find that somewhat counterintuitive, quite frankly. And then as far as educational records, and I know this is one of the subjects that has come up repeatedly. Well, first of all, in order for it to be an educational record, it has to be directly related to a student. And I know that I've been involved in litigation where there are arguments that it is limited to academic records, which would of course exclude disciplinary records, which again is rather counterintuitive as well. The other problem that school districts have is data that is inextricably intertwined. In other words, you've got data regarding two individuals and the problems that school districts have. And I know I read an article in the St. Paul Dispatch, or rather the Star Tribune recently, and the issue was transparency of school districts with respect to responding to data requests. And I will tell you that I agree, and I know that Mr. Gemberling's here, and I used to work rather closely with Don Gemberling when he was with the Department of Administration. But I remember there was a comment in there about that school districts have, and the issue was whether or not school districts are responding appropriately to data requests. And I will tell you that it's a very difficult thing for school districts to respond to data requests because they have to ensure, because of the penalties, that they don't release anything that is private data. And there was a comment in the article that said, well, districts have the responsibility of maintaining records in an easily accessible format. That is true as far as being able to retrieve the records. But accessible doesn't mean necessarily what people are entitled to when they request the data, because we have to, and school districts generally take a rather conservative approach because of the penalties that exist. I know one issue that has come up during the course of this hearing has to do with directory information. And directory information, I agree with the superintendent from the Anoka-Hennepin School District, it generally includes matters related to sports. The problem that you have under the Data Practices Act with respect to directory information is it's specifically authorized, and it's public data under federal law. And the federal regulations list what is included in directory information, as does state law, and it can include anything that is not basically harmful to the student if released. School districts don't really have the authority under the law to determine who they're going to release directory information to, because directory information is public data. And you can't, and under the Data Practices Act, you can't ask somebody who requests data what the purpose of them requesting it for. You can't. That's prohibited. And so the school districts don't have the authority, and I don't know that the authority exists for the legislature to adopt legislation that restricts who is entitled to directory information, because I think it would be contrary to federal law. What it does do, though, is and I agree with the superintendent from Anoka-Hennepin, it does, the actual inclusion of what is directory information is within local control. And school boards can decide, school districts can decide what, provided it's not something that if it was released is harmful, they can decide what's included in directory information. I've seen some school districts that have a more broad policy regarding directory information, and some school districts that have a more restrictive policy with directory information. But that's already permissible under the law. There's no change that is required. Some other comments. When you look at the question then becomes really what are educational records? And the definition of educational records is very broad. It's very broad under the federal law. I know my firm was just involved in a lawsuit. The decision is pending in Hennepin County District Court regarding a videotape, a school security videotape. But the bottom line is, under federal law, it includes, records include any information recorded in any way. Doesn't make any difference. In any way, including but not limited to handwriting, print, computer media, video or audio tape, film or microfiche or microfilm. So education or records are defined very, very broadly under federal law. And the issue of school computers has been addressed already during the course of this hearing. I would submit that that's already addressed under FERPA by their broad definition of records. But again, in order for it to be educational records, it must be directly related to a student. It doesn't mean anything that a school district has which may tangentially touch upon a student. And I know the California law was also mentioned during the course of this hearing. I would submit that it's not necessary because, again, federal law defines records very, very broadly. It includes biometric records, by the way, now, and it has to be directly related to the student. Absent that, I don't really have any further comments unless somebody has any questions.
Any questions for this testifier? See none, thank you very much.
Thank you.
I hope you heal well and quickly.
I'm not going to be walking the dog, I can assure you that.
Staying away from the corgi for a while. All right, very good. Next up is Ben Feist. And then Ms. Bell and Ms. Schultz, will you be coming down together? Yes. Okay, very good. Welcome to the commission. Please state your name for the record.
Madam Chair, members of the commission, my name is Ben Feist. I'm the legislative director for the ACLU of Minnesota. And first off, thank you very much for having this hearing today so we can start to get to the bottom of a very big issue here regarding student data. And as we've already seen, there are a lot of moving pieces here. The ACLU of Minnesota has been interested over the last several years in a lot of privacy and technology issues. And most of those up to this point have been focused on law enforcement technologies and how that interacts with our privacy. In this case, the ACLU has been very interested in particular, the pieces that are in House File 1507, dealing with student information systems and these one-to-one programs like the iPads and other devices that kids are allowed to bring home, and what type of data is being collected through these systems, how that data is protected when it gets into third-party hands, and ultimately the question of who owns this data. Is this data ultimately the property of these students, or can this be used by third parties for marketing and otherwise made into a real commodity? As we've seen in many other instances with all of the data points that are available, it's very easy for this information to be used for advertising and marketing purposes, and can also be used in very damaging ways, especially when we have very specific personal information that gets into the wrong hands. So we think it's really important that Minnesota come out here and understand that while there are certain protections in place through federal law and through the Data Practices Act, that it also makes sense to look at these specific types of technologies and understand that we should be providing extra protections in state law, where right now there's very little that specifically addresses these issues. So again, I don't have a lot of specific to add here, other than the fact that we very much support everything that's in House File 1507 as it currently stands. The idea behind this is simply to make sure that we know what happens with the third-party access. We know that we're protecting students from being marketed to, and with these other protections in place, we won't have to worry, hopefully, when new things come into the market as well. So the purpose, again, is not to stop schools from being able to use any type of technology. We generally support the use of these technologies, and we just want to be clear that the proper thing is for parents and students to be in control of this and be able to opt in to how this information is going to be used. So I think the bill, though long on paper, is actually pretty straightforward, and something that I hope we can see some movement on in the coming session. But with that, I'm happy to answer any questions.
All right, thank you. Any questions for this testifier? Thank you, Mr. Feist.
Thank you.
Okay, next, Linda Bell and Kirsten Schultz with Minnesota Advocates and Champions for Children. Welcome to the commission.
Thanks, Madam Chair. I'm Kirsten Schultz.
I'm Linda Bell.
All right, very good. Go ahead with your testimony.
All right. Madam Chair, committee members, I'm Linda Bell, and I'm here on behalf of Minnesota Advocates and Champions for Children and our over 5,000 members who routinely question the use of their children's data without their parental consent. Based upon our state statutes, third-party privacy notices, and personal experiences, we know that when a student logs into their computer using their SSID login, data is collected and flies instantaneously to a number of different entities. Where does this data go? Well, it goes to school district warehouses, state and federal government agencies, including 40-plus contracts maintained by our own Minnesota Department of Education, over 150-plus contracts maintained with the U.S. Department of Education. It goes into the MARS system, which reconfigures our data for the state longitudinals, into the state longitudinals. MinLink, other MDE-approved vendors like the Parent Portals, TIES, and Infinite Campus, and literally thousands of curriculum and testing companies that have sprung up over the last 8 to 10 years, and more every day, survey and mental health data collection, companies and researchers, as well as the new social, emotional, or values data collectors whose main goal is to put together a profile on each student. Representative Lucero has stated many times in the Data Practices Committee and in other situations that our educational data statutes are out of date, lacking many changes to protect the technology now being utilized by our school districts. As a teacher, I witnessed the rise of technology in our schools. You might remember in the 1980s when the schools first opened using computer labs. They were in self-contained rooms, using bulky Apple computers, and with group instruction. That was group instruction. Schools routinely purchase technology license packages to offer instruction in word processing and other programs, as well as supplemental lessons. The majority of the early lessons were not online or interactive. And then the 1990s brought in CD-ROMs and the continued use of floppy disks and Microsoft PowerPoint. Since the 2000s and on, students are now required to have their own personal device or laptop and to work personally one-on-one with curriculum companies utilizing artificial intelligence, otherwise known as computer adaptive. At this point, data collection has become much more sophisticated. They time out the amount of time it takes for a student to touch the keypad when answering a question. It's very sophisticated at this point. And profiles can, and we are being told that they are being created on each child. Many of our parents ask, how can school districts keep track of where personal student information is going and whether it is being shared by entities who are supposed to safeguard and keep our children's data secure? Once student and family data is out there on the open market, it is sold and resold over and over again. And I know this because this happened to my family due to a school data breach. We know recently that the South Washington School District unfortunately breached, it was their own breach by mistake, student and family private information. Parents were informed of the breach and what aspects were actually breached. But unfortunately, there's a lot more that the school districts could have done, and that's in HF 1507, which covers data breaches and provides the steps that parents can then take to protect their family as their information continues to be sold and resold. Just a couple of quick facts. That in 2013, the College Board and the ACT were sued for selling student PII. 2014, the SAT was included in that litigation. In 2013, UC Berkeley, students sued Google over privacy invasion. In 2014, parents sued Google over their apps for education, whereby Google scanned contents of email messages which allegedly violated federal and state wiretap laws. And on and on. The litigation with some of these companies, corporations, you can research it online. It goes on and on. And just to make this point, that total advertising revenues made up 91% of Google's $55.5 billion in 2013 profits, a significant percentage of which is likely to be derived from the 30 million student users worldwide. HF 1507 will bring much needed protections to students and families very simply by helping schools implement best practices in handling data. The fourth section in the bill, titled Student Information Systems, provides specific requirements that must be in a contract with a school and software provider related to the security of the student data transmitted or collected, and requires that the contracts include provisions that identify who owns the data, how to handle a data breach, how and when data must be destroyed, how and when data can be accessed, and provisions on the sale of the data. And for me, I think, as my colleague Ben Feist said, the important question really is who owns the data. Who owns the data is who is owning all of this information, and it could be used for nefarious purposes. And so I thank you for listening to my testimony. MAC endorses HF 1507 and seeks your consideration for this very serious bill. Thank you.
Thank you. We'll hear from Ms. Schultz, then we'll open it up to members for questions for either one of you, if that's okay. Ms. Schultz, go ahead.
Madam Chair and members, HF 1507 will not change the way school districts can use technology. It will not restrict teachers in the use of testing or online curriculum. This bill is about how that collected data is handled. It is a necessity for teachers to understand more about how to handle student data concerning third parties. The last section of the bill implements timely training for all teachers, staff, IT directors, and other individuals who access student data regarding the FERPA law to prevent unauthorized access or disclosure of student data. Additional training would be either annual or as the need arises. The data being collected through programs like Class Dojo, TIES, Infinite Campus, along with testing, surveys, online curriculum, and apps, is why the training on FERPA is so important. With privacy being so valued, it is imperative that teachers receive this training to help protect our children's data. No teacher or administrator intends to put our children's data at risk. With the mind-numbing pace of changes happening in this arena, it is time to examine the effects on our children. Teachers are the closest to students in the educational setting, and it is important that they have the opportunity to understand more about student data. The burdens of developing this training will not be on the districts or MDE, as the U.S. Department of Education and the Family Compliance Policy Office provides forms, best practices, and visual training. Thank you so much for your time.
Thank you so much. Do we have any member questions for either one of these testifiers? Senator Limmer.
Thank you. Ms. Bell, you made a comment that students are, and I didn't get this, are they encouraged or are they required via their personal data devices to contact curriculum companies?
No, those are contracts that the school district set up. You know, the online curriculum now, there are contracts with certain curriculum companies, and those contracts are made with the school district. Students are receiving their curriculum through these online companies, is my point.
Senator Limmer.
And Madam Chair, Ms. Bell, are students required to give personal information to the companies in order to make contact
Well,
with their curriculum program?
yes, there are surveys many times that will pop up in between lessons, and you're not allowed to go to the next lesson until you complete the survey, much like gaming. You know, there are surveys in all those little bitty games, Minecraft and SpongeBob and all of that. The surveys pop up there too. So there's collection going on in all of these aspects, and they'll ask personal questions.
And Madam Chair, Ms. Bell, if a student would refuse to answer some of these questions in order to move on to the next program, what happens?
Ms. Bell.
Thank you, Madam Chair. Well, the savvy student would try to bypass it. I think generally they can. I don't know if they get stuck. There's that possibility, but I think generally they can bypass the survey.
Madam Chair, are they instructed on how to bypass the question in the event they felt uncomfortable answering a question?
I've never heard of that.
So no notice is given to a
No
student,
notice.
and in this case, probably not a parent either,
No, no notice. Sorry, Madam Chair.
right?
Any other member questions? Representative Lucero, I failed to do this, and I apologize, but I was going to give you, after nonpartisan staff gave their rundown, their presentation, I was going to ask you if you had anything to add, so I will ask that now. It's your bill.
Thank you, Madam Chair. I was going to give a few remarks, so I appreciate the opportunity, for sure. And Madam Chair, so we know that the law is not keeping up with technology. Technology innovations, capabilities are accelerating every year. And there is both good and bad with new technology and new capabilities. It can help increase efficiency, it can help decrease cost, it can help increase educational opportunities, but at the same time, there are definitely drawbacks and potential risks to privacy intrusions and stuff like that. And there isn't, it seems as if there isn't a day that goes by where there isn't a new breach headline. Not necessarily in the educational space, but in data breaches and in any space. And most recently, we're seeing the Equifax, very personal information, unfortunately being compromised. South Washington School, or County Schools was mentioned. Bloomington Public Schools, I think, was another one, headlines earlier this year as well, just in terms of Minnesota and in education. And these data breaches, and the fact that technology innovation continues to accelerate is definitely creating more awareness and more sensitivity by the population. And in the context of K through 12, by parents in regards to their students. And that's why this issue is so timely and one that definitely needs to be addressed. The bill 1507 that I've worked on in last year or this year, we've did a hearing in civil law, so I appreciate that. In the previous session, we a similar bill was I gave a bill hearing in the Educational Policy Committee in the House, and so I have a PowerPoint where I gave some background and went over some general topics. But one of the things that I was highlighting was in regards to Minnesota. Chapter 125B is titled Education and Technology. It's 5 pages in length, and it dates back to 1980. And for the most part, with a few exceptions of just some very minor changes, it hasn't changed since the 1980s. But look at how technology has changed dramatically since then. Again, there's definitely work to be done. So, and when it comes to 1507, I'm very proud that this topic, student data privacy and privacy in general, cybersecurity, it's not a partisan topic. And I'm very proud that there are multiple co-authors on both sides on this, demonstrating that this is a very bipartisan topic. When it comes to the industry, so I'm in the cybersecurity industry, and we have very many regulatory compliance mandates that we have to adhere to. And those regulatory compliance mandates are the product of the continued recognition of the demand to keep people's information, sensitive information, PII, personally identifiable information, and other information private and secure. And there are consequences if there isn't due diligence given to ensuring security and maintaining privacy. And when there is a breach, it becomes very costly and people become accountable. Some of those regulatory compliance mandate examples in the last decade, 15 years, it would include Sarbanes-Oxley, GLBA in regards to financial institutions. There is PCI, it stands for Payment Card Industry. It's not a government mandate, but it is regulating the credit card information. And when I say it's not a government mandate, that's a recognition by the credit card or merchant industry to self-impose mandates, being proactive. And there are a whole host, HIPAA High-Tech are more examples. So one of the things I also have to be sure to make a distinction when it comes to this conversation is security versus privacy. So when it comes to cybersecurity, most understand the concept of ensuring data that is supposed to be limited access is maintained as limited access. So only authorized parties are able to access the information. But that's not the only consideration. Privacy is also important. It's information that is collected Not is it just kept secure, but is it authorized and was it collected with knowledge of the person and authorization from the person from whom it was collected? So again, it's privacy and security. So 1507, again, I've mentioned it's a bipartisan bill, and we continue to work throughout the interim here, meeting with multiple stakeholders. Because this touches so many different areas, we're proactively trying to reach out, have a dialogue to the many stakeholders that are involved in this topic to come to the greatest consensus that we possibly can. And just some examples that we've met with recently or reached out to, the Minnesota Association of School Administrators, Minnesota High Tech Association, Minnesota Private College Council, the Minnesota School Boards Association, the Minnesota Coalition on Government and Information, the Minnesota Department of Education, the industry, which makes up Amazon, Google, Apple, and Microsoft, and many others, the University of Minnesota, Minnesota State Colleges and Universities, and there are more stakeholders. So we look forward to continuing those conversations to refine this language to get the greatest consensus that we can. And then the goals versus what we're not attempting to accomplish here in 1507. The goal, the intent of the bill is to protect student private data and to ensure parental authority over their students' private data. What the bill is not intended to do, it's not intended to prevent schools from engaging in day-to-day operations. We are not seeking to limit or to prevent teachers from teaching in the classroom. We want teachers, obviously, to be the most effective they can in the classroom. As a technologist myself, as a former college instructor, the intent of the bill is not to limit the use of technology in the classroom. The next generation coming up, it is incumbent upon them to learn as much technology as possible so that when they go off into their various careers, that they are well skilled for the demands of the competitive workforce. And so we absolutely don't want to limit the use of technology in the classroom. And it's not to prevent schools, there was a discussion on directory information. The intent of the bill is not to prevent schools from having rosters or brochures for sporting events, yearbooks from being printed, to prevent photography services, ordering of class rings and things like that. So, Madam Chair, I know we didn't go through a rundown of the bill in this commission meeting today, but there is a lot of language that, again, it becomes very, very large from its first appearance, but that's because there's a massive amount of work to be done in this area. And I should also say that the bill as it sits before us is the compilation of approximately 6 different bills. And we're still strategizing on the best way to move forward. We may, and it's most likely we're going to break those out again into individual bills and to allow them to move through committee potentially separately. So, Madam Chair, again, I appreciate the opportunity. I appreciate the larger crowd than I was expecting, actually, and but it demonstrates the interest in this area, and I very much appreciate the testifiers coming down. So I continue to look forward on the hard work and members of the committee as we move forward.
Thank you. Thank you, Representative Lucero, for your hard work on this subject, and it is a big one. It's a big one to take on, and and ladies, thank you for being here to testify. I believe,
Madam Chair, are we going to have an opportunity for additional discussion?
yes, we will. I think I'm going to open it up to anyone in the audience wishing to testify, and I believe Mr. Heller was wanting to testify. And then Mr. Gimberling, did you want to testify? Okay. Welcome to the committee. Please state your name for the tape and go ahead with your testimony.
Thank you, Peggy Scott, Chair and Commission Data Practice. I have a handout. I was wondering if it's okay if I can provide it. It has to do with my prior conversations from last year. It's been a while since March 3rd. I know I'm not going to revisit that, but I am going to talk specifically on education. I've been involved in that. I was wondering if that's okay if I can provide those copies to you.
Sure, you can give them to me, and we can get them distributed. Or Ms. Olson will get them from you. Thank you.
Again, my name is Rick Hiller, unofficial representative, twice exceptional and print disabled. Print disabled is found in the Higher Education Act. There's only 2 lifetime handicap learners, blindness and print disability. Also, the twice exceptional is found in Minnesota Statute 120B-15. The twice exceptional are students that get a label on their ability, but they're gifted. However, there isn't a definition in there. Now, regarding data practice, I think it's important that we start looking at the functionality of electronic. We look how we're going to the word is, what's the word? Selection, acquisition, and use. That's basically 508 refresh. Currently, there's 2 school districts in Minnesota, the academies, the Purpose Center for the Gifted and the Deaf and the Deafblind, that are quasi, they're school districts. However, they're required to follow content accessibility law, Minnesota Statute 16E 03 subdivision 9, which requires them to make their content accessible from the get-go. Lately, there was a complaint filed with Minute. They're currently analyzing both the face page websites. I believe there was 300 plus errors on the Purpose Center, over 1,000 on the blind. So what does this all mean? Obviously, we all know about 508 protection for students. However, universal design, as it relates to, again, selection, acquisition, and use, which is a rule for teachers to apply, goes a little bit further, because universal design for learning was started in 1985 at MIT or Harvard when they took a federal funding stream called CAS.org. And when they reset it 2 years ago, universal design is for everybody. Now it's called aim.cas.org. So what is this all about this selection, acquisition, and use? Well, frankly, it's about how people acquire it. I acquire information orally, and I see it. I'm a firm believer that if you provided another means other than a silent read, you just made it more accessible for everybody and ease in use as it relates, as it interfaces. When stuff becomes non-image, you can interface and analyze data. But if it's image, how can you analyze it? That's one piece important about, when you talk about information. I've had some discussions with Anoka Hennepin and OCR. And I asked for the whole file electronically. However, they never used a tendency warning, what the severity of my disability is. So that kind of went on the wayside. They ignored me. And that was asked for the whole file in electronic format that could read out loud. So what's interesting about this is it disconnects individual parents with what's going on in the school system, where if it was the academy or the Purpose Center, there wouldn't have been an issue, because I would have probably took it to the Office of Human Rights. As you know, there's a statute there that provides those protections, and there's a $500 cap that people can bring a suit. But the whole thing about this is everybody will benefit from this. The handouts I provided today was a discussion on March 3rd. John Lesch's letters in there. I hope he makes that fully accessible as we move ahead. Basically, that correspondence I handed out, and the goal is basically the goal is provide security and fairness and sameness in a timely manner, frankly, and if this applies to the legislature, not just to state agencies, and frankly, I think it needs to apply to school districts, because as we move ahead, everybody benefits from this. Everyone will benefit from this. And obviously, Mr. Bach and Thiessen offered to be able to see the numbers on that white sheet, not the yellow one, because the yellow sheet is from the March 3rd, those handouts. But I also make sure that you post these online, because it's going to be ongoing discussion, I assure you that. And these documents, again, be posted online, and Greg makes them accessible. I think it's a relevant piece of the legislature for your engagement, participation, and responsibility you have to provide fairness, sameness, and transparency for everybody. I'm open to any questions. However, I know that this is not about the legislature, it's about education. and all lifetime learners. So anyways, I appreciate your time. If anybody got any questions, I'm welcome to them.
Okay. Member questions for Mr. Heller? Thank you for providing us with this information.
Thank you, too. And information's one thing, but unless we apply it, it doesn't go anywhere. So I'm glad you consider that as well.
Thank you. Mr. Gamberling, is there anyone else in the audience that wishes to testify? Okay. Mr. Gamberling, you get to wrap it up, and then we're going to have a discussion. If you want to go ahead and introduce yourself for the tape and go ahead with your testimony,
You
that'd be
bet.
perfect.
My name is Don Gemberling. I'm with the Minnesota Coalition on Government Information. I'm not quite sure if I'm here for them today. I'm probably here more for your benefit of what I know historically and otherwise. I was interested in the discussion about director information. If you were having this discussion in 1980, you would learn that most school districts in 1980 were not only designating the entire list of possible data in FERPA as directory information, but some of them were actively selling student information to anybody who'd buy it, including names, home addresses, phone numbers, etc. Over time, that produced a reaction from parents. Why am I getting all this mail in my kid's name? And they would discover that it came from the school district designating home address, et cetera, as directory information. Now, Senator Limmer's comment about patchwork, the patchwork is still what's real, okay? I think, if I remember right from a recent trip to the Stillwater School District, they continue to designate student home address as directory information. Under FERPA, they can do that, okay? Now, there was some discussion about is there any opportunity for you to control that? What FERPA actually says is these are examples of what can be designated as directory information. And I think the state has the full authority, because FERPA also says you can extend more privacy than FERPA does, to say we don't want you to designate certain things as directory information, okay? And you've actually tried that in the past. The problem is finding the trick, the balance point between making it, some of the examples that were used in those discussions, well, if we do it this way, we can't say that my grandson scored the winning touchdown in the football game because we can't disclose student names and athletic participation. But I think it's important as you go forward to understand where you are with these things currently. I appreciate what Representative Lucero is doing because it's desperately needed. But part of what I think you really need to look at is the laws that we have, starting with FERPA, and by the way, the Minnesota Data Practices Act predates FERPA, we were ahead of FERPA, rely heavily on notices and administrative processes to accomplish things like the protection of student privacy. The directory information example is a good one. But it only works to protect student privacy if parents are fully informed of what, for example, a school district has designated as directory information and how they can object to that, okay? And so in the mechanical processes of how districts and educational institutions do things, somebody should look at how they do them. And I'm going to submit, if you're just posting that on your website, and it's very hard to find on a website, then you really haven't done what I think both FERPA and the Data Practices Act require, which is full disclosure to parents as to what is designated as directory information, and full and easy methodology of saying, I don't want that to happen for data on my kid, okay? So much of what goes on in these two laws involves process, okay? And there's a whole bunch of reasons for that. I'll give you another example. Somebody talked about the tennis warning. Well, and there's lots of issues with the tennis warning. But the question becomes how, in the educational setting, how is a tennis warning actually delivered to parents? How is a tennis warning actually delivered to students? Because the ultimate protection that the tennis warning represents is the opportunity to learn what's going to happen with information that I'm being asked to disclose, how it's going to be used, who else can get it, whether or not I have to provide it, is there some legal rationale for me to do that? And I then have the opportunity to say, now that I know all that about this information, I don't want to give it to you, okay? In a situation where I don't have to give it. But what's critical there is, how is the notice given? Is it some straightforward, direct way of communicating? If, for example, is it on a data collection form? Is it on an online form that says, we're going to ask you the following questions on this form, and therefore here's your notice as required by section 1304, the legal citation, as opposed to calling it attendance warning? A couple more examples. FERPA relies heavily on parents being informed. From day one, parents, FERPA was actually a form of parents' rights legislation. That's what it came out of. That's why it's called the Family Educational Rights and Privacy Act, okay? Because it says very strongly that parents need to have information to be able to control educational information about their kids. So FERPA, again, says every year you give a notice to parents as to a whole variety of things, how you handle information, things like how you decide who within a school gets access to data. And again, parents can't know what's really happening unless that notice is given to them in some direct and understandable form, okay? If it's posted on page 27 of a website, I'm going to tell you, you're limiting parents' ability to exercise the rights they have under FERPA. So, there's some strange issues laying around related to privacy and educational data. And I don't have kids anymore in school. I tend to rely on what happens to my grandchildren. My daughter goes a little strange when I say to them, did you ask them for your attendance in the morning, and what did they tell you? But I'll give you an example of one that was around for too long, and I wonder what is still happening with it. For the statewide student identification number, we once had a very long discussion with the Department of Education about it when I was still working. And what we said was, you know, this number is actually people's social security numbers. It's kids' social security numbers. And the response from the Department of Education was, no, it isn't really. And I said, how can you say that? Okay, it says, da-da-da-da-da. That's a kid's social security number. Well, we put the number of the school district in front of that, and therefore it's no longer a social security number, which I thought was an interesting artifice, but it just doesn't work. Now, the University of Minnesota, the state college system, they were just directly collecting social security numbers. That all happened at a time when federal law said you couldn't collect social security numbers. You could try and collect them, but you had to tell people whether or not they had to provide them. So once again, the notice kind of discussion comes up because students didn't get a notice that said, as required by the Federal Privacy Act, you really don't have to give us this number. What they got was a notice that said, unless you give us the number, you can't register for school, okay? Now, the question I have there is, I don't know if that is still the state ID number that's used in all the state systems, like Mars. But what happened to all those numbers that were collected for a number of years? They're still, I assume, still out there somewhere. So, in closing, as you develop new laws, and I had this discussion with the ladies who testified, you have to look seriously as how you're going to enforce this stuff, okay? You know, I could tell you probably, I don't know how many hundreds of instances in which I know for sure, as an attorney, I could prove beyond the shadow of any doubt, which I don't have to do in a civil case, that tennis warnings were not being given to students. What do I do with that? Well, frankly, I can't do much without it other than complain, okay? Because under the Data Practices Act, you have to sue people to enforce your rights. And to sue people, in most cases, you need to have some damages or it isn't worth suing. So enforcement continues to be an issue in all that you do, okay? Because if you don't have effective enforcement, then you don't have an effective law. The Supreme Court, I can't remember exactly when, decided, because it was an open issue, you can't bring a private cause of action under FERPA. You can't. You can't sue. You can go to the federal government and you can make a complaint. And you know when your complaint will be resolved? In about 5 years, okay? Because the office that enforces FERPA is a little tiny office. And what they're going to say, and I've seen these, is school district X or university Y violated FERPA, and here's how they did it. And then it will say in bureaucratic ease, go and sin no more, okay? That's what it'll say, okay? And so, to the best of my knowledge, and council may know more, no educational institution in this country has ever lost a penny because it violated FERPA, okay? Because that's the ultimate penalty. By contrast, under the Data Practices Act, you can sue them. So, and I kind of like that better because at least it makes people more aware. So, if you have any questions, I'd be happy to answer them.
Any member questions? Senator Limmer.
Thank you, Madam Chair. Mr. Gemmerling, does FERPA prevent a state from making universal recognition of data as opposed to the patchwork allowing individual districts from defining what they want to collect in the directory list?
Mr. Gemberling.
Madam Chair, Senator Limmer, you've made a number of tweaks in the Data Practices Act to what FERPA says, because FERPA does allow you to extend more privacy, okay? And I would argue that if the state were to say, you cannot designate, you can only designate the following things as directory information, that's not a violation of FERPA, okay? And even if it were, it would take them 5 years to tell you it is. So I should be more kind. I'm sympathetic to the people at the federal government because they really do operate with limited resources. That'd be one way to do it.
Senator Limmer, follow up? No? Okay.
That's all I need to know.
Senator Kent.
Thank you, Madam Chair. Just to clarify, Mr. Gemberling, thank you. I always appreciate your perspective and institutional knowledge about all these issues. But just for clarification, on behalf of one of my school districts, Stillwater, they do not include home address information in the directory. I just want to make sure that we didn't have erroneous information out there.
Madam Chair, Senator Kent, before I went to Stillwater, I looked real hard on their website for their policies and procedures on data practices, and they're not easy to find.
I have a link. I'll share it with you. But
I have a link. See, that's the problem.
Any other questions from members for this testifier? Thank you so much, Mr. Gemberling.
Thank you.
Anyone else in the audience wishing to testify?
Thanks.
Seeing no one, open up for a member discussion on this topic. Senator Kent.
Thank you, Madam Chair. I really appreciate this discussion. This is an issue, and I agree with Representative Lucero, and I know we've all worked on this. I don't think there's a single person who doesn't share absolute commitment to protecting the privacy of students, because it just makes basic sense. This is an issue I've worked on. I had a bill in 2016, and Representative Scott, you carried it in the House. Senator Limmer, you were a co-author. Representative Lucero, I believe you were a co-author as well, that looked at a number of these issues. And, one of the challenges with this is, you can throw everything in a basket, or you can try to look at different components of it. My bill was more focused on some of the technology pieces in working with vendor relationships and clarifying some of that and updating it. It passed out of both bodies, but didn't quite make it through the conference committee process, which is still a bit of a mystery to me. It had broad bipartisan support. I have not had a chance to go through HF 1507. I wasn't aware that that's what we were going to be talking about today, so I would love to spend some more time looking at this, and I'm happy to talk to Representative Lucero about it further. The most recent version of my bill, and it was introduced late in 2017, following trying to have some discussions with stakeholders. We also knew, not being a policy year, it wasn't going to go very far this year, but its most current version is Senate File 1980, and I hope we can have good bipartisan support and continue continue these discussions, I think it would be great if we could, keep talking about this issue and be able to dive into it a little deeper. In quick consultation with Ms. Pontius, who really helped draft the original version of that bill. One of her concerns in just initially looking at 1507 is that we might not have third parties addressed in this, which is one of the greatest concerns that we have in dealing with some of these issues. So I look forward to it. I really do appreciate you bringing this up, but I hope we'll have a chance to keep talking about it because it really is so important.
Any other comments from anybody? I just want to say that this is a topic that I hope that we move forward this legislative session, provided that, the legislature is funded to have a session in 2017. Because I think it's really important to all of our constituents and their families. And I'm very thankful for the two testifiers with the parents group, because they've taken the bull by the horns on this issue and really have delved in. They're very knowledgeable. And that's who we all represent up here. And that's what I aim to do with the outcome of this bill, is represent the parents and the families of these kids. I do want to continue this discussion on this, and I think hopefully before session begins, with our fingers crossed, right, that I'd like to have a hearing on both your bill and Representative Lucero's in full, and then have the commission act on those and either say yay or nay, or this is what needs to happen, so that when the legislature hopefully begins in February, that we have weighed in on those bills. So without further ado, I believe Ms. Olson has a copy of our future meetings to hand out to everybody, so you can get those on your calendar. Appreciate her being proactive in getting those put together for us. So our next meeting will be October 5th, Thursday, October 5th. And we're just going to stick with the 2 to 4 p.m. And I know Representative, Representative Schultz told me she couldn't be here before 1 o'clock on certain days of the week. So that's why I put them in the afternoon. And I know it kind of puts us right at the cusp of getting out of here at rush hour. But I appreciate everybody being here today, and for members' input, and for everyone in the audience that was here and testified. And please know that my door's open. I know Representative Lucero would welcome your comments, and I'm assuming Senator Kent would as well on the bills that are before us. With that,
Move to adjourn.
there's been a motion to adjourn. Is that Robert's Rules of Order, isn't it? Meeting is adjourned. Thank you.